Hello everyone, this is Dhananjay Sharma and you are watching World Legal Help Organization. In today's video, we will discuss what is circumstantial evidence. But before talking about circumstantial evidence, we will talk about what the term evidence means. The term evidence has been derived from a Latin term evidere, which means to discover, to ascertain or to prove. According to the Indian Evidence Act 1872, Section 3 of the Act defines the term evidence. And according to this, evidence means and includes all statements which the court permits or requires to be made before it by the witnesses in relation to any matter of fact under inquiry. And all such statements are called oral evidence. And second part of the definition, which talks about all documents, including the electronic records, which are produced before the inspection of the court. And all such documents are called documentary evidence. So primarily, as per the Indian Evidence Act, there are two categories of evidence, that is oral evidence and documentary evidence. But in today's video, we are going to discuss about a different aspect of classification of evidence, that is direct evidence, and we will primarily focus on circumstantial evidence in this regard. So direct evidence, which is also called positive evidence, is about the real point in controversy. The evidence which is about the real point in controversy, that is, which is about the real fact in issue, that evidence is called as direct evidence. Let's take an example. A murdered B and C was present at the time of happening of the incident and saw the whole incident with his own eyes. C is an eyewitness in this regard, and here we will consider C as a direct evidence in the present case. Now coming to the circumstantial evidence. Circumstantial evidence relates to the series of other facts than the fact in issue. But by experience, it is found so associated with the fact in issue by reason of cause and effect that it leads to a satisfactory conclusion. We can say that circumstantial evidence does not relate to the fact in issue. It does not relate to the real point in controversy, but it relates to a series of other facts than the fact in issue, and by reason of cause and effect that it leads to a satisfactory conclusion. Here in circumstantial evidence, the theory of cause and effect is of much importance, and it is only the basis of this theory that a person leads to a satisfactory conclusion in a particular case. Circumstantial evidence is primary and direct. That is the fact from which the existence of other fact in issue is to be inferred. That needs to be proved by direct evidence. Let's suppose the example of circumstantial evidence. A was tried for the offense of murder of B under section 302 of IPC. There was no direct evidence was available on record. However, three major facts were recorded at the time of investigation. First, A and B were seen together going towards the place of occurrence of the crime, that is where the dead body of B was found. After the alleged crime, B's dead body was found and A was seen alone at the crime scene, that is near the dead body. And it was also noted that few days before the incident occurred, A and B had a fight over whatever issue it may be. So, even in the absence of any direct evidence, on the basis of all the three series of facts, although they do not relate with the fact in issue, but it relates to a series of facts, and there was motive available with A, that is in course of revenge he murdered B, and there were also various other facts available on record that on the basis of circumstantial evidence, for B's murder, A can be convicted in the present case. In regard to circumstantial evidence, even the Honorable Supreme Court of India in the year 1952 has held in the case of Hanumant Govind Narkunkar versus State of MP. That is the circumstances from which the conclusion of guilt is to be drawn. First, they must be fully established. Second, all the facts so established must lead to the only conclusion with the guilt of the accused. Third, the facts so established must be of a conclusive nature and tendency. And fourth, that all the other hypotheses of the guilt must be excluded, and the only hypothesis which needs to be proved, that should be laid from that particular evidence. So only when these four evidences or when these four facts are proved, then only the conviction can be made on the basis of circumstantial evidence. So that was all with regard to circumstantial evidence that we discussed in the today's video. Hope you like this video. Thank you very much.